In this video, I'll share foundational United States federal employment legislation prior to 1990. These 5 acts shown in the boxes are listed from earliest to most recent. They'll be covered in summary format, indicating who they apply to, the provisions and compliance requirements. The website where the act can be found is listed. The Equal Pay Act, EPA, of 1963 was the first anti-discrimination act to protect women and prohibits discrimination on the basis of sex. Prior to the act, the comparable worth standard was used by United States federal government to make compensation decisions. When Congress passed the act, it deliberately rejected the comparable worth standard in favor of the equal pay standard. Jobs are considered equal if they require equal skill, effort, and responsibility, and if they are performed under similar working conditions. Equal pay, however, does not mean the same as comparable worth. Although 2 jobs may require similar levels of skill, effort, and responsibility and have comparable worth to the organization, they do not have to be paid equally if they are different jobs or in different job categories. The Act applies to employers and employees who are covered by the Fair Labor Standards Act, FSLA, and is administered and enforced by the Equal Employment Opportunity Commission, EEOC. The Equal Pay Act provides 4 exceptions to the employer's obligations to pay male and female employees the same wages. As shown in the table displayed, the Act allows for differences in pay when they are based on a bona fide seniority system, wages and salaries are based on the length of service, a merit pay system, pay is determined by legitimate performance measures, a system that measures quantity or quality of production, or a differential, which is based on any factor other than gender that fairly measures factors other than sex. The Civil Rights Act of 1964, Title VII, is considered one of the crowning legislative achievements of the civil rights movement. It was first proposed by President John F. Kennedy, then survived a strong opposition from Southern members of Congress, and was signed into law by Kennedy's successor, Lyndon B. Johnson. It prohibits discrimination in employment and applies to employers with 15 or more employees, employment agencies, labor organizations, state and local governments, and educational institutions. It established the Equal Employment Opportunity Commission and outlines the procedures that the Commission should follow to prevent unlawful employment practices. The 7th Amendment of the Civil Rights Act of 1964, Title VII, outlines 5 major protected classes: race, color, religion, sex, and national origin. Sex was a late addition to the original 5 as it was intended to keep women excluded, but the act passed. There are now also protections for physical and mental disability, reprisal, and most recently added sexual orientation. It is unlawful to deny employment opportunities, training, or career advancement to protected classes or to an individual based on their association with someone in a protected class. Title VII allows for limited exceptions to its requirements. These are shown on the table listed from left to right. Bona fide occupational qualification, BFOQ. This occurs when religion, sex, or national origin is reasonably necessary to the normal operation of a business. Religious organizations. They may give preference to members of that religion. Educational institutions. These were not originally subject to Title VII, now included when curriculum propagates the protected class. This is allowable. Work-related requirements. This depends on the intent and impact not to discriminate. Take note, national security clearance that is required for a position is not protected. Indian reservations. They may give preference to Indian applicants and employees living on or near the reservation. Bona fide seniority systems. The use of tenure to allocate employment rights and not to discriminate is allowable. Affirmative action plans. Complying with affirmative action legislation to correct a past injustice is permitted. A deeper dive on BFOQs as they come up more often. An employer who discriminates based on religion, sex, or national origin must demonstrate that the attribute is a BFOQ necessary to the normal operations of their business. The concept of business necessity has been narrowly defined by the courts. When a practice is found to have a discriminatory effect, it can be justified in one of three ways. 1, it is necessary to the safe and efficient operation of the business. 2, it effectively fulfills the purpose it's supposed to serve. Or 3, no alternative policies or practices would serve the same purpose with a less discriminatory impact. Race is never a BFOQ. The Age Discrimination in Employment Act, ADEA, is designed to protect employees who are 40 years of age and older from arbitrary and age-biased discrimination in hiring, promotion, training, benefits, compensation, discipline, and terminations. Employers are not even allowed to provide different health or medical benefits to older workers than younger workers, nor can they stop making contributions to an employee's pension just because that employee has reached retirement age but chooses to continue working. Early retirement programs are allowed under ADEA, but employers must be very careful to avoid using early retirement incentives as a means of forcing older workers to quit. A review of relevant court cases indicates that employers facing age discrimination charges have very little reason to be optimistic, since the court decisions have generally been decided against them. Employers who are charged with age discrimination basically have 4 legal justifications for their decisions. 1, an employee is hired as a firefighter or police officer by a state or local government. 2, the employee is a top executive or policymaker. 3, the employer has a genuine seniority or benefit plan. Or 4, the employee is discharged or disciplined for just cause. Age can be a BFOQ if necessary for the normal operation of the business. Early retirement programs are a convenient way for an employer to achieve a satisfactory reduction in force, but they must not violate the Age Discrimination in Employment Act. Here are some guidelines. Incentive. The employer should offer an incentive that's fair and that will attract employees. Eligibility requirements. The employer should provide clear and rational requirements for employees to become eligible. Employee acceptance. Participation must be knowing and willingly and voluntary by the employees. ERISA coordination. Employees should receive a summary plan description for the benefits they will be offered. The Equal Employment Opportunity Act of 1972 prohibits employment discrimination. The Act extended coverage to Title VII to entities that had been excluded in 1964. This includes educational institutions, state and local governments, and the federal government. In addition, it reduced the number of employees needed to subject an employer to coverage by Title VII from 25 to 15 and required employers to keep records of the discovery of any unlawful employment practices and provide those records to the Equal Employment Opportunity Commission, EEOC, upon request. The Act also provides protection from retaliatory employment actions against whistleblowers. It provides litigation authority by the EEOC in the event that an acceptable conciliation agreement cannot be reached. In the case of public employment, the EEOC refers the matters to the United States Attorney General to bring the lawsuit. Protected classes are how federal law conceptualizes protections against discrimination. The understanding of classes continue to evolve either incrementally through the courts or through federal legislation. Societal responses to new issues of discrimination generally start the process. The EEOC protected classes shown on this pictorial view includes the groups from Title VII with additions for veteran status, genetic information, and sexual identity. The Equal Employment Opportunity Commission, EEOC, is the first step in enforcing Title VII for employees wanting to pursue a discrimination claim. The Equal Employment Opportunity Commission Act provides administrative guidance for processing of complaints by the agency, which is depicted in the process flow. Starting at the top center box and moving down, an employee may file one or more discriminatory charges, and the agency does a procedural review and may deny all or part of it within a 30-day window to appeal. If the agency moves forward, the employer is notified of the charge or charges and then has the opportunity to respond, which should be taken seriously and responded to immediately. The employer should in no way interfere with the rights of the employee or employees pursuing the charge. The agency has 180 days from the day of filing to determine reasonable cause of the charge with the basic of 3 possible outcomes. On the left, option 1 is the EEOC finds reasonable cause. The agency is empowered to sue non-governmental entities, including employers, unions, and employment agencies, in the event that an acceptable conciliation agreement could not be reached within 30 days of notice to the employer. The agency can offer to settle the complaint with all parties, which will be bound if they choose this option, and the claim will be settled. The employee also has the option to ask for a hearing, which transfers the claim to be handled by the EEOC administrative judge. Another option is to request a right to sue letter to pursue a lawsuit in the federal district court within 90 days. The investigation may be extended by another 180 days if new charges are added to the complaint or if new complaints that must be added to the original complaints for investigation. The employee can also agree to an extension of up to 90 days. In the center, option 2, the EEOC does not decide. If more than 180 days has passed since receiving the employee's charge and the agency has not finished its investigation, the employee can wait for the agency to complete its investigation, ask for a hearing, which transfers the claim to be handled by the EEOC administrative judge, or request a right to sue letter to pursue a lawsuit in federal district court within 90 days. On the right, option 3, the EEOC finds no reasonable cause. When the investigation is finished, the agency notifies both parties. Employee is notified of the right to pursue a lawsuit in federal district court within 90 days. Remedies available to the employee who is discriminated against in violation of Title VII includes back pay, compensatory damages, and punitive damages. Title VII sets caps on the amount of compensatory and punitive damages, which vary by the size of the employer. Congress amended Title VII of the Civil Rights Act of 1964 with the Pregnancy Discrimination Act of 1978 to define pregnancy as protected within the definition of sex for the purpose to clarify that discrimination against women on the basis of pregnancy, childbirth, or any related medical condition is an unlawful employment practice. It defines pregnancy as a temporary disability and requires accommodation on the job if it is necessary. It guarantees the employee rights to return to work to the same or similar job with the same pay following her pregnancy disability.